Controversial change in how North Carolina teenagers are charged in crimes is less than 2 months away from beginning. Rather than being charged as adults, 16 and 17-year-olds will start being charged as juveniles under the Raise the Age law. But there's a lot more to it than just that. The law creates its own category that a lot of people don't really understand. Channel 9's Mark Becker joins us now live to explain.
Well, we'll give it a shot, Scott, because it is complicated. Even the police and attorneys who will be working with it say that it is a difficult thing to understand, and we will see. But perhaps the best example we can use is one that happened just Monday. A 16-year-old charged here with attempted murder for a shooting in Uptown Charlotte. Less than a day after police arrested 16-year-old Raheem Chiclette for the shooting uptown on Monday, we knew his name and that he'd come here from Georgia, police say, with a stolen gun. But if it had happened 2 months from now, it would be a lot different. Chiclette would still be a juvenile, and we would know very little about him or his case and many others like it. And with teen crime on the rise here, that worries people.
They are dangerous kids.
Cheryl Jones with Court Watch says raising the age limit of juveniles from 15 to 17 will only shield many of them from serious consequences by keeping them in a juvenile system that simply hasn't worked.
With all of the programs that they have to help put these kids on the straight and narrow, it hasn't worked. So why do you think 2 more years is going to make it work?
If you are accused of committing a Class A through G felony...
At a workshop this morning on the new law, police, attorneys, and social workers here learned that, in fact, 16 and 17-year-olds charged with the most serious felonies, like robbery, rape, and murder, will have their cases transferred to adult court within 90 days.
The only real difference is that there'll be a short stopover where their attorney will be a juvenile attorney.
Emily Tamlin with the Council for Children's Rights says keeping young defendants like Raheem Chiclette out of the public eye, even for a few months, will help everyone step back and make sure they're getting it right.
We've got 16 and 17-year-olds, they can't vote, they can't engage in a lot of adult activities, and yet we're willing to sentence them to public opinion before we even understand what the context of the case is.
Now, just to let you know how complex this new law is, this handbook they handed out this morning at the seminar, more than 100 pages long, and even the attorneys and police who were there say it'll take a while to get adjusted to it. Scott?
All right, our Mark Becker live tonight. Thanks, Mark. There are also limits to sentencing under this new law. If someone's convicted as a juvenile, they'd be sentenced to a juvenile detention facility. If a 16-year-old is convicted, they can only be held until they are 19. A 17-year-old could be held until they're 20.